Anything then from the defense?
Yes, Your Honor. May I please introduce our team?
Would you please?
Your Honor, my name is Andrew Michaelowski, and I am presenting the opening statement for the defense.
Your Honor, my name is Audrey Davis, and I will be conducting the cross-examination of Liz Michelle.
Your Honor, my name is Terrence Sun, and I will be conducting the cross-examination of Les Moore.
Your Honor, my name is Lynn Strakovsky, and I will be conducting the cross-examination of Detective Christopher Riggs, as well as presenting the closing arguments for the defense.
Your Honor, my name is Mary Witzel, and I will be conducting the direct examination of Professor Pat Ives.
Your Honor, my name is Chris Park, and I will be conducting the direct examination of Joel Bird.
Your Honor, my name is Henry Shovitz, and I will be conducting the direct examination of Willie Freeman.
Your Honor, my name is Nick Petty, and I will be performing the duties of the bailiff.
And the witnesses?
Your Honor, my name is Ian Fifield, and today I am Pat Ives.
Your Honor, my name is Ryan Farsi, and today I am Joel Bird.
Your Honor, my name is Ian Newton, and today I am Willie
Thank you.
Welcome. Does the defense wish to introduce their team?
Yes, Your Honor.
I'm sorry, this is the prosecution.
Thank you, Your Honor.
Sorry, I flip-flopped from the last round. Just 2 minutes and I should figure that out. Please introduce your team.
My name is Daniel Chen. I will be crossing Willie Freeman, as well as Pat Ives, and doing the closing arguments.
Your Honor, my name is Donald Sabady, and I'll be presenting the opening statement for the prosecution, as well as leading the trial.
Your Honor, my name is Alden Moss, and I'll be leading Chris Riggs.
Your Honor, my name is Aaron Pekas, and I am portraying the part of Leslie Moore.
Your Honor, my name is Nathan Goodman, and I'll be crossing Jay Bird.
Your Honor, my name is Enrique Murray, and I'll be portraying Chris Riggs.
Hello, Your Honor, my name is Mark Gonzalez, and I'll be leading Leslie Moore.
Your Honor, my name is Jeremy Sherman, and I'll be portraying Luca Charlton.
Your Honor, my name is Noah Jan, and I'll be the clerk.
Okay, are we ready to proceed?
Yes, Your Honor.
Okay, the prosecution then may give its opening statement.
Your Honor, members of the jury, we gather here today because of the loss of a life, the life of Devin Frost. Ms. Frost was a young, determined woman who had started a small business with the defendant, Willie Freeman. Ms. Frost had developed a gambling habit over time and soon became in debt to a local loan shark, Luca Charlton. In order to pay back her debt, Ms. Frost began to take money from her business. Willie Freeman, upon hearing this, became infuriated, threatening to make Ms. Frost pay for what she had done. A few days later, Devin Frost was found dead. Your Honor, members of the jury, today the prosecution will prove beyond a reasonable doubt that the defendant, Willie Freeman, intentionally caused the death of Devin Frost, murder in the first degree. In order to do this, the prosecution will show you that the defendant had the motive and the means to kill Ms. Frost. The prosecution will call to the stand Leslie Moore, Detective Riggs, and Luke Contralto. Les Moore, a certified public accountant, will tell you that the defendant had called him to see why the business was losing money. He will tell you that after reviewing the financial and business records, it became clear that Devin Frost had been stealing money from the business, almost $300,000 in the past 2 years. Les Moore will testify that after finding out about Ms. Frost, the defendant said that she was going to make Devin pay for this. Detective Chris Riggs will testify that if Devin Frost's death had really been a part of a mob hit, her body would have been roughed up, a way of showing other people that the loan shark meant business. Today, the defense will try to discredit Mr. Riggs by claiming that he had ties to Luke Contralto, by trying to tamper with the evidence in a previous case. A case that ended without him being charged, suspended, or even reprimanded. And lastly, the prosecution will call to the stand Luke Contralto, who will testify that if he thought there was any chance Devin Frost would not pay him back, he would not have loaned her the money. So how could someone who was still getting money from Miss Frost find a motive to kill her? The defense will also call to the stand 3 witnesses, the defendant, Willie Freeman, Joel Bird, and Pat Ives. Willie Freeman, the defendant, will testify that she had been furious with Devin Frost for stealing money from the business. Because of Miss Frost, the defendant was going to lose everything that she had worked for. Willie Freeman will admit that she resented Devin Frost's ability to come up with cash easily. That money lost meant everything. Willie Freeman will financially benefit from the death of Devin Frost, $500,000 to be exact, through a buy-sell agreement that she claims to not have known about. Yet her signature is on the paperwork. They will call to the stand Joel Bird, a man with no affiliation to Lou Contralto, who will testify that Lou confided in him in this murder. And lastly, they will call to the stand Pat Ives, who is being paid $3,000 to render an opinion on this case after reviewing the paperwork for only 4 hours. Your Honor, members of the jury, Lou Contralto had nothing to do with the death of Devin Frost. Lou Contralto had no motive. Devin Frost was still a source of income for Lou. Willie Freeman, on the other hand, lost money to Devin Frost, and the only way to get it back was through the buy-sell agreement. Because of Willie Freeman's irresponsibility, Devin Frost is dead. Today, the prosecution will ask you to find Willie Freeman guilty on all charges. Thank you.
Okay, defense may give this opening statement.
May it please the court, counsel, members of the jury. My name is Andrew Michelossi, and I am representing Ms. Willie Freeman in this trial. The prosecution wrongfully accused Ms. Freeman of murdering her beloved business partner and friend, Ms. Devin Frost, in the first degree. However, Ms. Freeman is a cook, not a killer. The prosecution has the burden of proving, beyond a reasonable doubt, that Ms. Freeman had both the motives and the means to perpetrate such a chilling act. As Judge Irwin will instruct you, Ms. Freeman is presumed innocent until proven guilty. So any hesitation in this matter, any reasonable doubt, means she must be found not guilty. As the defense, we will show you the extensive amount of doubt in this case, and I trust that you, members of the jury, will choose to right this unjust accusation by acquitting Ms. Freeman. Looking over her life, it becomes quickly evident that Ms. Freeman is caring, not cruel, and naive, not conniving. She is a cook, not a killer. Ms. Freeman worked hard to get into the most prestigious culinary school in the country, and then as a chef at one of Portland's finest dining establishments. Ms. Freeman will testify from the very beginning she appreciated Ms. Frost's enthusiasm, financial abilities, and their shared dream of owning a restaurant. Ms. Freeman never mastered the art of finance, rather focusing all her energy on providing good people with good food. When she learned of Ms. Frost's embezzlement, she was initially angry, but this anger quickly shifted into pity. She was sad that her dear friend had gotten herself into such a dangerous situation and wanted to help Ms. Frost. However, Mr. Contralto, the cold-blooded loan shark who had been lending Ms. Frost gambling money, was a killer, not a cook. He was motivated to kill Ms. Frost because she had become dead money after bleeding her business dry. As Mr. Contralto will testify, he had been tailing Ms. Frost for 2 weeks. Accountant Les Moore, who was auditing Chalice during this time, will testify that he heard someone threatening Ms. Frost on the phone and noticed burn marks on her arms as well as bruising around her neck. The highly qualified organized crime expert, Professor Pat Ives, will testify that this kind of physical assault is very common in organized crime. Mr. Contralto will say that he has no recollection of hurting Ms. Frost, but the denial will not be convincing. Then he'll go on to spin an elaborate story of the night of Ms. Frost's murder, and how he apparently saw my client threatening Ms. Frost at knife point. However, ask yourselves why Mr. Contralto would not have taken action to help Ms. Frost in this situation. Would he let a $200,000 debtor die in front of his very eyes? And Mr. Contralto struck a deal with the prosecution in return for his testimony here today. You will also hear from Mr. Joel Bird, who comes here today without a deal. As Mr. Contralto's former cellmate, listen carefully to his statements about what Mr. Contralto told him in jail. And Miss Devin Frost, although tragically unable to be with us today, did leave a crucial clue as to who her killer may be. As Detective Briggs will testify, her last words, written on bacon strips on the floor of the freezer where she was found dead, Red Killer L, the only conceivable suspect whose name begins with an L is Mr. Lou Contralto. Detective Riggs initially arrested Mr. Lou Contralto. However, his suspicions moved to Miss Freeman due to fingerprints at the crime scene. But these fingerprints were not found until 10 days after the murder. And Detective Riggs has had prior involvement with the mob, especially Mr. Lou Contralto. Members of the jury, you're here today to do justice in this case. A good-hearted country girl has been wrongfully accused of the murder of her beloved business partner and friend, Miss Devin Frost. We cannot revive Miss Frost from being murdered, but we can avoid the equally grave injustice of sending her business partner to jail. Ms. Freeman will speak to you today and look you in the eyes so you can see for yourself that she is a cook, not a killer. We believe the evidence in this case will show an extensive amount of reasonable doubt, and trust that you, members of the jury, will judge this case fairly and use all the evidence presented to come to a just conclusion that Ms. Freeman is not guilty. Thank you.
Prosecution may call you first, please.
Your Honor, the prosecution would like to call Les Moore to the stand.
Okay, Les Moore, please come forward and be sworn in.
Do you solemnly swear that the testimony you're about to give faithfully and truthfully conforms to the facts and rules of the mock trial competition? You be seated and spell your name and say your name and spell your last name for the court.
My name is Leslie Moore, M-O-O-R-E.
Hello, Leslie Moore. Could you tell the court a little bit about yourself?
I graduated from the University of Oregon in 1981, where I went right away to work at the Arthur Anderson. At the University of Oregon, I won the Luke Bacchioli Award, which is the top in your class.
So, can you tell me a little bit more about what you did after you graduated?
Then I went to, after I graduated in 81, I went to work at the Arthur Anderson firm, and I was an accountant there.
So why did you decide to specialize in forensic accounting?
I decided to
Objection, Your Honor, relevant.
In just a moment, I will give more information about this, why you entering this as a forensic accountant.
Rulers include their backgrounds, so go ahead and continue along those lines.
Thank you, Your Honor.
All right, so may I approach the bench? You tell me what this is.
That's an accurate copy of my record.
Thanks so much.
Are you going to give me that document?
Yeah.
I'm not going to receive that document.
I'd like to now enter in that witness for forensic accounting.
Any objections?
Yes, Your Honor, we believe that a proper foundation has not been laid as to why this witness should be entered as an expert witness.
In later questions, I have some, he will have to do some, answer some questions, so he needs to be first entered as an expert witness.
Okay. The exhibit that you showed the witness and had identified as the witness's resume, are you going to be offering that into evidence? Okay. At this point, the objection is sustained. You may want to ask one or two more questions about the background.
Thank you, Your Honor.
Tell me how you first met Willie Freeman.
I met Willie Freeman after giving a speech called Realizing Your Full Potential. It was about helping with all the businesses. So Willie Freeman confronted me after the speech because he was wondering why her business was in the red, even though they're doing it so well with all the consumer reports.
So why did you contact me?
Contacted me, as I said before, because I was wondering why the business was in the red and what could have caused that, even though the customers seemed very satisfied, and there was even a report in the Oregonian about it.
So in the first week of being in Charlotte, what was your understanding of what you heard of the conversation that Devin had?
Well, I heard something about Devin saying that she owed money to somebody, and at first I thought that was the vendor, because if you don't pay the vendor as a restaurant owner, if you don't pay the vendor, then your business will go up.
So, because of the problems that Willie Freeman confronted you, what did she want from you?
He wanted me to complete an investigation and for me to see why her business might be in the red.
Okay. So, what did you notice that this week
Well, I noticed that there are 2 occasions where Devin Frost spilled coffee over all the records, and I noticed her talking several times over the phone to somebody, and I also noticed a shadowy figure across the alley.
So, as a forensic accountant, what is your understanding of how most restaurants lose their money?
Most restaurants lose their money due to employee fraud, employee embezzlement, which is fraud.
So after completing your 2-week forensic investigation, what did you come to the conclusion?
Came to the conclusion that there had been fraud and that Devin Frost was stealing money from the restaurant.
Objection, Your Honor. Rule 701. This is opinion testimony by a lay witness. This witness isn't an expert and therefore can't testify on these financial matters.
Okay. She's testified that she conducted an investigation, that she is an accountant, and that she conducts seminars. What is it that's lacking from the defense perspective as far as qualifications to be able to examine?
This witness has not been sworn in as an expert. Is therefore a lay witness.
Okay. And it is, do I understand correctly that the nature of the objection is that this witness must be tendered as an expert before the witness can testify to any kind of accounting investigation?
Yes.
Okay. Counsel?
As you said, I do believe he should be sworn in as an expert, because he did go to the University of Oregon, and he knows his background as forensic accountant.
Are you tendering this witness as an expert at this point in time?
Yes.
Okay. And so now that the witness has been tendered, do you have an objection to continuing?
No.
Do you object to this witness being considered an expert at this point in time?
Yes, I still believe a proper foundation has not been laid as to why this witness should be sworn in as an expert.
Okay. The objection is overruled. The court will receive this witness's testimony as to accounting. The proper foundation, not the proper foundation has been laid.
All right, thank you, Your Honor.
Go ahead.
Yeah.
You may.
All right. Could you tell me what Exhibit 2? Show me what is your understanding?
This shows one of the receipts for a certain payment, and on January 14th, 2010, and all the payments on that same day.
How about Exhibit 3?
3, this shows the amount of money made over the day on the 8th and 9th of February 2010, but it shows on the 11th of February 2010 that the money put in the bank, and it's a lot less than the money that was made from both of the prior days.
Objection, Your Honor. This testimony is using evidence that has not been entered into evidence. I mean, it's using exhibits that have not been entered into evidence.
That objection is overruled.
Thank you, Your Honor.
may I exhibit exhibit 2, or may I enter exhibit 2 and 3 as evidence?
Any objections to receiving exhibit 2 or exhibit 3?
None, Your Honor.
Yeah, received.
Final one, could you, what is your understanding on this?
Well, this here is showing a check that was written to Devin Frost and not to the restaurant. Therefore, the restaurant never received this money here. It was written straight to Devin Frost. So she was able to pocket the money.
I would like to enter exhibit 4 as evidence.
Counsel, do you object to exhibit 4?
Can I have a copy of all these exhibits?
Please make sure the counsel has seen a copy of these exhibits, please.
We're going to object on the grounds of Rule 802 hearsay, because this is an out-of-court statement.
Okay. Can I see exhibit 4, please?
Yep.
Counsel, the objection that you have is hearsay. Do you have a copy of exhibit 4 reported?
Yes.
Hearsay is an out-of-court statement. What is the statement that appears on exhibit 4 that you're objecting to?
The statement says, paid to the order of Devin Frost.
Counsel?
I believe it should not be declared as hearsay because of the rules, and I think it should be declared as evidence because, as my witness already said, it shows information that supports the idea that the restaurant was legal.
The statement paid, or the comment here where it's written paid to the order is not a statement as it would be interpreted as far as hearsay. It is simply circumstantial evidence of the payment of this particular amount of money. I will overrule the objection and receive the exhibit.
Thank you, Your Honor.
Thank you. So how did Willie Freeman react to the information?
Well, Willie Freeman at first kept saying, how could this happen? And as I kept filling in more and telling him more information, he was obviously upset and told me that I'd done my job and I could be excused and she would deal with Devin Frost.
When you came back to the restaurant to retrieve your pencil, what did you understand from Willie and Devin's discussion?
Well, I understood that Willie was very upset, and I was sure I heard something along the lines of Willie saying that she said that she needed the money right now, or she would kill Devin Frost. And then at the end, I heard very clearly, "You'll get your just desserts," said by Willie Freeman.
Okay, would you agree with me that this is exhibit 5?
Yes, I would agree with you.
Right, so, what can you tell me about this?
This is the buy-sell agreement that both Willie Freeman and Devin Frost signed on June 15th of 2007. And what that's saying is that if one of these two people were to die, the other one would get a $500,000 insurance payout.
I'd like to know the narrative in 5 as evidence.
Objection?
Yes, Your Honor, we object on the grounds of hearsay of Rule 802.
Counsel, do you have an exception, or are you not offering for truth?
Well, I think this should be in here as evidence because this was a major agreement between Devin Frost and Willie Freeman.
Okay, so since it's an agreement between the defendant, are you telling me that it's a party under permission? Okay. Why don't you talk with your counsel for a second and tell me whether or not you have answered that question.
The answer is
objections overruled.
Thank you, Your Honor. All right, so what did you learn about the restaurant's buy-sell agreement?
Well, I learned that either Devin Frost or Willie Freeman were to die somehow, then the other one would get the $500,000 insurance payout.